The content of this video, as well as the thoughts, views, and opinions expressed herein, belong to the presenter and do not necessarily reflect the views of Brigham Young University or the Church of Jesus Christ of Latter-day Saints.
Hi, my name is Rob Bolick. I'm an attorney practicing in estate planning and asset protection. I've been doing this my whole career, worked in both in Salt Lake, Utah Valley, Las Vegas, and as of now back in Utah. The last lecture I did wear a red tie, so as you can tell today is a blue tie. My wife happened to go to a red school. I went to the blue school. Our daughter did go to BYU for a while, but then she met this guy up at Weber State and ended up graduating there, so it's appropriate that red and blue, she graduated from the purple school, of course. But for this, I am true blue. I did my bachelor's BYU, law school at BYU. My dad is a doctor, practiced at Utah Valley Hospital. He actually set up the medical technology program for BYU. And he taught a class at BYU in the honors program on history of medicine. So what I tell people is, for me, it's pretty much genetic. My parents met at the Y. I was born Utah Valley Hospital, and to prove that it's virtually genetic within my DNA, I tell people I actually have truly a Y chromosome. So that's me. Let's go ahead and get involved in our topic today is advanced estate planning. So last session talked about basically about wills and trusts and how a living trust will avoid probate. Will is, consider that as an engraved invitation for your kids to go to court. So will, not good. If you like your attorney more than your kids, get a will. If you like your kids more than the attorney, get a trust. That's kind of the basics there. So today we're going to talk about more of the advanced topics, fun things that you can do within your trust to help protect your spouse and kids from bad things that can happen in the world. So we're going to talk about how estate planning is different now than it was a while ago, and more importantly, how you can protect your kids and spouse, and also talk about taxes. So next lecture we have in a part of a 4-part series is asset protection, what works, what doesn't work, LLCs, series LLCs, contrasting with corporations. Fourth in the series is about domestic asset protection trusts. These are awesome, amazing tools. We're going to compare ones at least in the West here, Nevada, Utah, Wyoming. The nice thing is you don't have to be a resident of any of those states to be able to use the laws. We're going to talk about that in the 4th lecture about how that can happen. One of the main things there is home. People have a lot of equity in their home. Utah homestead, for example, is only $42,000 of equity, not a whole lot if you've owned it for a while. How you can protect it from the rest of the world is with an asset protection trust, lecture number 4. So for today, 2 types of trusts, very creatively named A trust and a B trust. So we'll jump into there. So an A trust is your standard revocable trust, family trust, living trust. So we're going to have a married couple, John and Mary. There's really not an artificial line down the middle. It's all in one trust, all of their assets. Both have equal access to do whatever they want to. Just divided it up here for illustration purposes. John happens to pass away first. In an A trust, what happens is basically his half of the estate, or whatever his share is, then passes to Mary. There's actually really no passing. It all just stays within the one trust. So John checks out. He's gone. Mary continues with the trust. She's the trustee. So she has complete control as the trustee. The advantages of an A kind of a trust are basically it's very simple and easy. So you set up the trust. Regardless of which spouse passes away first, the survivor just carries on. So no changes, at least legally, for this. Hopefully she misses him and was sorry he's gone, but other than that, legally it's all the same. So nothing changes. So in the A trust, after he's gone, she's the trustee. Are there any disadvantages? Is there any downside to this? Possibly. So what would happen if they had, prior marriages and they each had kids from before? We have a potential for some unexpected things happening. So if children of first spouse to pass away could be at risk. Also, if Mary is not financially astute, or I should have said John in this, we're not trying to be gender specific, so one spouse isn't. The main thing is if they have a hard time saying no. I know a lot of people, some that I'm related to, that somebody asks for something, it's like, it's not quite scriptural, ask and ye shall receive, but that's the way family members do, is they just give it away to their own detriment. Okay, so let's jump into a story. John and Mary came to see me to set up a family trust. John had 2 kids from a prior marriage. Mary didn't have any. Okay. I discussed with them pros and cons of an A-B trust, and we'll get into the A-B trust in a minute, but just sticking with the A trust, I was trying to explain to them some of the advantages of a B trust in their situation, but no. Recommended that they set up an A-B trust to protect his kids in case he happened to pass away first. They assured me, oh no, we love each other. True. We care about each other. Also true. And we're sure that the other is going to do the right thing. Maybe not quite as true. So they decided to do an A trust. John died a year later. 2 weeks later, Mary was back in my office. I'm sure the body was completely cold by then, but it was a really short period of time. She said, oh, the kids were mean to me at the funeral, and I never really got along with them anyway, and so I'm going to amend my trust. His kids are out, my family is in, and so that's what happened, and frankly, there's nothing that he could do about it. I don't know if John is doing some somersaults in the grave or not, but actually in the spirit world, he probably doesn't care about this so much, but maybe he does, I don't know. Anyway, they opted for the A-B trust, or the A trust instead of an A-B, and because she had the power to make any changes, she took that opportunity. So, all right, so now A-B trust. So A trust, very simple, one trust, everything's in there. While they're both alive, both spouses can do whatever they need to, whatever they want to. Each can act independently. Spouse 1 moves along, then the survivor can do whatever he or she wants. A-B trust is a little different. So again, you have one trust that's created during your life, and what it says is within this trust agreement, there's a provision that upon the death of the first spouse, another trust is created, the B trust. Okay. What are the consequences? Is the B trust is irrevocable. A lot of people get to have an emotional reaction about, oh, irrevocable trust, this is bad, I have no access to the assets, I can't do anything with it, my hands are tied, bad, bad, bad. Fortunately, none of that has to be the case. If you set it up incorrectly, you could tie the hands, but you don't need to. So basically, irrevocable is a good thing, it's not a bad thing. What it does is it gives you asset protection for the surviving spouse. That's a good thing. So here's how it would work. Being irrevocable doesn't restrict the survivor's ability to control assets. Still, if he or she is the trustee, they can buy, sell, trade, do whatever they want to, whenever they want to. Again, the surviving spouse typically is the trustee of both trusts. Sometimes if, again, in a second marriage situation, if you have kids from other prior marriages, if they want the ultimate in protection, what you can do is take one of the children from the deceased spouse's side to be a co-trustee with the surviving spouse. That way you kind of have a check and balance and can protect all the interests. Surviving spouse never likes it. It's typically a real hard discussion that you have with the clients about, do we want to do it or not? But that's up to you, of course. So what happens here is within the B trust, the advantage of it is everything in the B trust is protected from creditors. Again, just to contrast revocable with irrevocable, your standard living trust, family trust, revocable trust, on an asset protection scale of 1 to 100, weighs in at a 0. Okay, so living trust, 0, no asset protection. John or Mary gets sued. Creditors can attach anything in the trust. Completely different scenario with the B trust, with an irrevocable trust. Something can happen to Mary. She's in a car wreck. Somebody sues her. She has medical expenses. She has whatever may happen in her life. Whereas somebody can still get into the A trust, they can't get anything in the B trust. And so, frankly, one of the strategies here after the death of one spouse is you spend first from the A trust, keep everything in the B trust because that's more protected. So, the advantage of B trust, bad guys can't get in. Okay. So, and then the other thing, again, and if you have different beneficiaries, is you can have provisions in the B trust. What it says is when the survivor passes away, that the assets go to the beneficiaries that they had both agreed upon when they were both alive, that in the prior example of John and Mary, the survivor can't amend the trust to disinherit the kids of the first spouse to pass away. So that's that principle there. So, question, would you like to ensure that your assets don't pass to your husband's next wife or to her kids? Would you like it to make sure that it passes to, that the assets held for the spouse are held for his or her benefit, they're creditor proof, and they also can't be used to disqualify the spouse from government assistance if that's necessary? Now, you got to make sure that the trust is set up properly. You can do it correctly and it works, and not correctly and it doesn't work. So let's just do an illustration of what this looks like. So in an AB trust, again, we have John and Mary here. A trust, we assume half and half for each. John dies first. Now we have the B trust that is created. So just to understand the graphics here, single line, revocable, double line, irrevocable. So A trust, B trust. Another way that you can remember it is A trust is above the ground and B trust is, well, that's his stuff. Okay. So John dies. Upon death, we have the B trust magically appears, is created in the original trust agreement. His portion of assets transfers down into the B trust. Okay. Again, Mary continues on as a trustee of the A trust, doing whatever she wants to. Typically, you'd have Mary as the trustee and beneficiary of the B trust. Both of these trusts, the A trust and the B trust, will last throughout their lives. So as long as she's alive, even if she becomes incapacitated and can no longer be the trustee, she's still the beneficiary. Everything is held for her benefit. Okay. So what does Mary get? From the A trust, whatever she wants. Again, no strings attached. From the B trust, a little bit different. It's whatever she needs. Now, here's what the IRS allows in this kind of a trust. So if Mary, again, is the trustee of the B trust, again, there's no restriction on buy, sell, trade, whatever she wants to do with the assets. That's her complete discretion. So as an irrevocable trust, again, the benefit is asset protection. So no creditor of Mary's can attach anything that's in the B trust. So Mary gets sued. Bad guys win, she loses, and we define very loosely bad guys as anybody who's trying to separate her from her money. Good guys is her. Okay, so no creditor of Mary's can attach anything in the B trust. Again, contrast with A trust. Compare with that, they can. So benefit of the B trust, nobody can get in. You see the arrow, they cannot pierce through the veil. So one of the things, going to some of the tax issues here, is things that we talked about in the prior lecture is getting a step-up basis. So one of the tax rules is that any capital asset that you have, real estate, home, rental property, whatever it is, stocks, any capital, anything that can appreciate in value gets what we call a stepped-up basis at death. So in the illustration the other day, you bought it at 100 and now it's worth 250. You have 150 of capital gain. If Mary, if somebody were to give that asset to their kids during their life, we have what's a carryover basis. So the kids would get the asset valued at $250. Their basis is the same as the donor at $100,000. So it's much better tax-wise, much more efficient for the assets to pass at death, which is what you want anyway. So number one rule in your estate planning thing is you never give anything away if you're going to need it or possibly need it. And so don't give things away to the kids now. Wait till John needs it, Mary needs it for their support. You don't know what the future is going to be, so they need these assets for their support because they do, and it's their stuff. They worked hard for it. So you receive something at death, that asset that was worth $100,000, the basis, they bought it, now worth $250 at death. The basis gets stepped up to fair market value. The kids can inherit it. They sell it the next day. There is no tax because there's no gain. The basis is adjusted to the fair market value. Now, one of the issues here when the B trust is, do you get a stepped-up basis? The tax rules are that if the assets are included in your taxable estate, you get the stepped-up basis. If they aren't included in your taxable estate, you don't get the stepped-up basis. Now, in the old days, like 20 years ago or whatever it is, go back in time, you had people's estates having a lot of value. The estate tax credit was smaller. The difference between those is going to be taxed under the estate tax rate. So back in the days when it was a $600,000 or $1 million exemption and their estate was above that, say it's a $1 million exemption, they have a $3 million estate, $2 million is going to be taxed at 40%. That's going to be $800,000. Yeah, $800,000 in tax. That's going to be a lot of tax. So one of the strategies under the prior law or prior planning, the same rules still apply today, is if you take the B trust, if you get the assets out of the estate, now what you've done is you get the estate tax, you get one credit in John's estate, no tax. Now Mary just has one credit to be used for her estate. Now anymore, the landscape's kind of flipped where the credit is now amazingly high and people's assets, their estates are underneath that. And so estate tax are more of a thing of the past. We're going to get to that later in this lecture. But the concept here, again, the principle is if it's in her estate, stepped-up basis. If it's out of her estate, no stepped-up basis. And so one of the tricks, basically what I tell people is where there's a will, there's a way. There's probably a very valid legal solution to be able to accomplish virtually anything you want. So if we do what's called giving Mary a testamentary general power of appointment within the B trust, what that will do is include it in her taxable estate, you can get the stepped-up basis. So that's a long explanation for there's still no downside if you set up the B trust properly to being able to provide her or him, whoever the survivor is, with asset protection during their life. So that's the B trust. So question, what can Mary receive from the B trust? Okay. Number one is all income throughout her life. So income is not an issue. What the IRS statute says is that you can get principal for health, education, support, maintenance. And so that sounds a little restrictive, but it's really not. Essentially, whatever she wants to or think of can fall somewhere under that category. Like, let's see, a cruise around the world. Yes, that's good for my mental health. Check. Let's say it's good. So the other thing is who decides whether the distribution qualifies? Well, it's pretty easy. It's Mary. If she's the trustee, she gets to make the decision. So although on its face it may appear there's some restrictions, really not if she's the one calling the shots. Okay, so that's kind of the basics between a trust, a B trust. And that's up to you to decide, consult with your attorney, whoever's assisting you with your estate planning, to figure out what makes sense in our situation. So any advantages of an AB trust? Oh, yes. So we've talked about asset protection. Essentially, no creditors of Mary can ever attach anything in the trust. So that's good, hers for life. The downside is the price you got to pay is he's got to go, and it's just his assets, but there is that benefit, okay? So again, all of the first spouse, John's half of the estate, is there for Mary throughout her life. You can make sure, again, in a different beneficiary situation, that you can put the restrictions there to make sure that it doesn't go to the next spouse. And by the way, this also is very gender specific. So husbands die first, the wife survives, she remarries. There's about zero chance that she's ever going to have him or his kids be beneficiaries of that trust. Not so for those of my gender. So wife passes away first, husband remarries. Oh, sure, you want something? Fine, great. Your kids, I'm okay with that. That's just my experience of the way the world works. So in this situation, if John had children from a prior marriage, you can protect it that way. So AB. Now let's go to income taxes. So question, now you have the B trust as a separate trust. Do you have to file a tax return for the B trust? The answer, of course, is it depends. So the tax returns for humans, it's a 1040. For a trust or estate, it's a 1041. So if Mary, here's another trick that you can do. So you don't want to have to file a tax return if you don't really need to, if it's no benefit. And so what we can do is within the B trust, if you give Mary the right, and this would be her right as a beneficiary as opposed to her power as a trustee. So if we give Mary the ability as the beneficiary to withdraw all of the income from the B trust, what the IRS says is we're going to assume that you exercise this right whether you did or not. And so as long as she is given the power to take all of the income out, she will be taxed on it even if she chooses to leave it in. So you get the best of both worlds there, at least. She doesn't have to file a 1041, and all of the income is just reported on her 1040, the same as if the trust didn't exist. Now, besides just the task, the cost, the time, whatever, of filing the 1041, the trust tax rates are greatly compressed. You hit the highest marginal rate at a very low amount, as opposed to individual returns, it's a much higher amount. So it's generally a lot more tax efficient to make sure that it's simply a pass-through entity and that the tax is all reported on her 1040. So a little tweaking that you need to do when you set these things up, need to address all of these issues and make sure you have it done correctly. So bottom line is all income is taxed on her return, whether it was distributed or not. Okay, next topic, let's just compare A versus AB. So A trust, it's simple, it's easy, no action is required, you don't have to do anything. With the B trust, again, you have to actually create a separate the B trust comes into being. What you have to actually do is transfer the assets. A lot of people say, oh my gosh, I've got the house, I've got these things. Do I need to cut the house in half, deed half to the B trust? Do I need to, what sort of things do I need to do? And the answer is no chainsaws required, no split deed. You don't have to do any of this. It's basically on value. So Mary, surviving spouse, is the trustee. She can pick and choose among assets. I want these assets here. I want these assets here. As long as they're, pretty close to, well, it should be exactly half and half, but generally pretty close as works. So she gets to choose which assets she wants to keep in her side, which assets in the B trust that are there then for the next generation. So, but the issue here is you have to actually retitle assets, which isn't as bad as you may think. If you have brokerage bank accounts, you just go to the bank, please switch, and they'll do it. Okay. Again, the advantage of the B trust is asset protection for the surviving spouse. And so that's the basics, AB trust. Let's move on to estate taxes. So again, the amount in 2024, you get a lot of different answers. Whenever I do seminars, it's a whopping $13.61 million per person. Or if you happen to be married, it's twice that for the couple. And so it's a very large amount. If your last name isn't Gates or Musk or something like that, you don't have to worry about it. For us mere mortals, it's a non-issue. That's the good news. The bad news is built into the tax law is what they call a sunset provision. So what this says is as of December 31, 2025, this goes away. So what had happened is they basically doubled the estate tax credit. Once you hit January 1 of 26, the credit drops in half. It would literally take an act of Congress to change this. The good news is it's indexed to inflation, so it keeps going up each year. And even if this, say 24, it's 13.61, assuming 25, it'll be maybe around 14 million. Half of that, 7 million, and particularly in times 2 per spouse. If your estate is under 14 million, really doesn't matter what Congress does, you're still going to be okay. Here's one of the things. A lot of people are confused between taxes and probate. So they're two different things. Taxes, IRS, federal government. Probate, state court action. Again, probate is the process of clearing title to the assets. You pass away, go down to your heirs. So kind of the hierarchy here. Lowest level for estate planning is do nothing. Above that, much better than that, is do a will. Will can avoid a lot of the problems, make sure everything is good. Better than a will is a living trust, revocable trust, family trust. To the extent it's funded, it avoids probate. The most common mistake people made is they go to the attorney, they set up the trust, and then they just don't put the assets in. So the trust will only cover the assets that are in the trust. It doesn't cover things that are outside of the trust, obviously. Which is why in your typical estate plan, you'll have a living trust, you'll have what are called pour-over wills. What they say is if there are assets outside of the trust that need to be probated, they still go through the system but aren't distributed to the beneficiaries. They're transferred or poured over like pitcher into the trust. The trust is the brains of the outfit. That says how it's going to be distributed to the beneficiaries and who's going to be in charge. So do nothing, not good. Will, much better. Trust, better yet. The only thing perhaps above that is there are a few states that have asset protection trusts. We're going to go into that in a lot more detail in the 4th lecture here, talking about how that works. But anyway, so the point here, taxes, IRS, doesn't apply to most of us, don't have huge estates. For those that do have huge estates, fortunately there's a lot of fun things you can do to make sure you can squash down values. You can do things to get the estate to value down and get estate taxes to zero. So all perfectly legal, never do anything, that's wrong, illegal, immoral, but on the other hand, you don't have to pay more than you're legally obligated to. So that's it pays to literally to do your homework, do your research, get the right things in place. So on the tax things, most states don't have a separate inheritance tax. The exception would be Washington State at $2.193 million. That's a whole lot less than 13.61. So I have some clients in Washington that say, do we move to, Idaho, Utah, Timbuktu, whatever, before you die? It's like, well, the taxes are pretty steep and you can still own your property in Washington. The tax is based on where you live as a person. So the state taxes is you personally, that's your obligation. If you're in one of the other 49, you're okay. So again, probate is the state court action. So just to summarize here on living trusts, you have asset protection after the death of a spouse. With the current exemption, it's really not a problem. The main focus is on what you can do. How can you protect spouse and beneficiaries? That's the next segment we're going to get into. And living trusts are awesome. They're a great way to provide for an orderly transition of your estate. So the question is, what kind of asset protection is available? We've gone over asset protection for surviving spouse with a B trust. Again, that's just the portion of the deceased spouse's estate. The nice thing is once it goes to the next generation, you can have 100% asset protection to the kids, the grandkids, the whoever it is. What kind of asset protection is available? And the answer is a whole bunch. So what you can do is you can set it up in such a way that your beneficiaries are completely protected throughout their life. Let's just give an example. Let's say your estate, let's say you have $1.5 million estate and 3 kids. I can do the math on this. So it's a sizable amount, whether it's $100,000 or $500,000 or $100 million, whatever it is. You give the children, in this example, $500,000 in an envelope. It goes into their checking account. What usually happens when money goes into a checking account? It gets spent. Okay. You don't want to incentivize the kids to do the wrong thing there. So what you can do is figuratively create a safe for the kids. Typically one separate trust for each child. And if they're responsible, they can be their own trustee. If they're minors or irresponsible, you can have somebody else, monitoring it, basically being the trustee. And once they hit a certain age, then they can become their trustee. So kind of under the old school line of thought was, hey, we're not going to have them blow it at once, so they get a third at 25, and they get a third at 30, and then they get the last one at 35, and after that, they're on their own. So we're going to give them 3 chances to don't blow. If you blow it once, you get a second chance or a third. What I like to do is, instead of doing that, is saying, whenever you think the kids are going to be responsible, give them the combination to the safe, and then they can become their own trustee. Some of the pushback I get on this is, oh, well, what if they don't want it? What if they don't like it in the trust? I go, that's fine. If they're the trustee, they take it out the next day. It's an empty safe and they can blow it. One of the sad facts of in our society, at least here in America, is the average time for an inheritance to be completely gone is 18 months. So, although some people are able to even exceed that, there's a psychological advantage of holding it in a trust instead of holding it in your bank account, your checking account anyway. And that is, oh, mom and dad set this up for me. It's kind of sacrosanct. It's some special funds here. I have an obligation to take care of it and invest it and use it properly. It's more of a psychological than a legal impediment, because as trustee, they can do whatever they want to, but at least you've created this other vehicle that you can help incentivize them to not blow it. I did have a client who was in last year. He was probably early 80s. This was his wife had passed away. He had remarried. She was probably mid 70s. So credit him for going for the younger women there. Good for him. He said, I love my wife. Well, okay, that's good. But I don't really trust her financially. I go, oh, tell me. So he said, and he came in alone, of course, not with her. He said she inherited $750,000 last year, and it was gone within 6 months. And so she was able to beat the national average. His concern in talking to me was, I want to take care of her for life, but whatever's left over that she doesn't need, I want it to go down to my kids. Say, oh, well, John, fortunately, there is a way. We can do this. And so going back to the AB trust, we can set up the B trust to have all of your assets go in there. If she's not particularly adept at financial matters or a little bit of a spendthrift, we can have, somebody else. You can have an independent trust company, or you can have one of your kids be a co-trustee with her, something to kind of make sure it's not gutted. Along those lines, a lot of times people will ask me, who is the appropriate person to be the trustee of the trust if the kid isn't responsible, or a spouse or whomever? My response is always, it's much better to have an independent third-party trustee to be the bad guy than it is, one of the kids to be the bad guys. So in the prior example, you have 3 kids. One of them is not good financially, is going to blow it, and another one is right of whoever. And so if you make the responsible child the trustee for the irresponsible child, that's really, in my opinion, an unfair burden that you put on one of the other kids to be the bad guy to his younger brother, sister, older brother, sister, whatever the case might be. I always prefer get an independent third party to be the trustee. There's all the banks and trust companies have their own, or most of the banks have a trust department, or you can also go to an independent trustee. They have an easy time of saying no, much more than older, younger sibling does. So just on the planning part, I always prefer to, help the kids out and don't cause civil war. But anyway, back to the story here. So you pass away to the next generation. You can have it in a protected vehicle, a trust. Think of it as a safe where the money is protected from any of their creditors. So we can protect the kids from themselves if they have, drug or alcohol or bad spending habits, whatever. You can put those restrictions in the trust. You can also protect them from what would be legitimate things. They're in a car wreck and they get sued for $1 zillion, cannot touch whatever's in the trust. Perfectly legal, perfectly fair. Anyway, you have these options. So is it important? It depends. So another case is, what about my child is handicapped or on government assistance? Okay. I can't provide any, so here's it's actually a misconception that I can't give anything to this child because it'll disqualify him from government benefits. True or false? The answer is, well, you can do it correctly, make it be false, or you can do it incorrectly and have it be true. So, but you do have the option of protecting your child. Basically, here's another thing. I say, well, I'll just give it to this other child, and I know that he or she will take care of younger brother, sister, whomever. Several problems with that. One is they're not legally obligated to do so. Two, something could happen to that child, and all of a sudden the money's gone. You never know. So you don't have to do the off book. You don't have to cut out the child. You don't have to do something sneaky there. It's easy to, the answer to that is bad. The thing there is you can set up the trust for the child. Okay. So, you don't have to disinherit them. You can create what's called a special needs trust, supplemental needs trust. You can have whatever the share is for that child that's there throughout their life, and it doesn't cut them off from government benefits. Okay. Most of you aren't in that situation. Here's a situation that we find ourselves in our day and age. When is not a good time to inherit assets? Okay. Child is in the middle of a divorce. Not a good time to get some money because half or more may end up on the other side. Okay. Child is in the middle of a financial crisis, getting ready to file bankruptcy. Somebody's coming after them. Not a good time to inherit something. Child is addicted to drugs or alcohol, large medical bills. So what we do in all of our trusts that we set up is think of it as a spigot. So we have the provision in the trustee to be able to turn off the spigot. Now is not a good time to inherit. We're not going to distribute. We're going to turn off the faucet. We're going to wait till whatever the bad thing goes away. Coast is clear. Everything is fine. Great. Turn on the spigot and the money can come out. So even in the trusts that require a certain distribution at a certain time or age, we put in the safety valve there, the ability to cut it off. So when is a bad time to inherit any of these things or your child? That's probably not the nice thing to say. Probably the more politically correct is child is financially irresponsible. So if your child wouldn't be good with it, you can put somebody else to protect your child from himself or herself. Okay. All right. So question, would you like to ensure that your assets pass to your children in such a manner that they are, again, divorce-proof, creditor-proof, bankruptcy-proof? You can do this by setting up this sub-trust within your existing living trust or asset protection trust. So question, would you like to ensure that your assets pass to your children in such a manner that they can only benefit them and not harm them? The answer is yes. So instead of giving things outright, instead of, 100,000 or 500,000 or whatever it is in an envelope, again, what we do is we can create these trusts. So in this example, 3 kids, you can protect the kids throughout their life. So we have Robbie, he happens to be my oldest. Cameron, he's not the oldest, he's a couple down. And Miranda, could be my favorite. I probably wouldn't tell Robbie that, but he might know it already. Anyway, I do have more kids than these, but these are the ones that I like the most. So these, just using this as an example, which on this topic, loving is mandatory. Okay, that's a commandment. We're even supposed to love our enemies, and sometimes those are people you happen to be related to, but loving is mandatory, liking is optional. So if people say I don't have favorites, I'm a little skeptical there that, yes, you love them all the same, but I'm guessing that's not quite true. So anyway, Robbie, Cameron, Miranda, divide the assets equally. You can see on this illustration, double line means irrevocable trust. And so we have Robbie. The trust is created for him and his adorable, lovely, smart, decent, kind, lovely grandchildren of mine. Okay. Robbie gets divorced. Hope that never happens. But, again, this in the world, it happens. So Robbie gets divorced. Can his wife get any assets in the trust? Hopefully you've figured out by now the answer is no. Why is that? Well, because it's not Robbie's assets, it's his kids' it's his trust assets. So again, here's the distinction between revocable and irrevocable. Basically, irrevocable asset protection, revocable no asset protection. So if it were a revocable trust, one of your kids gets sued, any creditor can get in. Irrevocable, they can't. It's a different entity. We will typically get a separate tax ID number. It'll be assets will be held in the name of XYZ Trust with a new EIN. And so anybody who does an asset search, nothing is going to show up under that trust because it's not in Robbie's name and it's not under a social security number. So as far as, the super sleuths in the ether world, they won't be able to see anything that's there. And even if they do, it really doesn't make any difference. Irrevocable trust, different than him. He gets sued. The arrow they cannot pierce through and get the assets. And then they say, well, what about if they need a house or they need this or that and spouse pressures child to take money out? Not a problem. So if the trust assets are used to buy the house, then the trust owns the house. You don't have to take the money out to buy the house. The trust can buy the house, and now the house is owned in the trust, not Robbie. Assuming everything's good, him, the kids, they all live there. Life is good. That's the way it should be, but the trust owns it, which again is going to help him if he ever gets sued. Nobody can touch whatever's in there. So let's go to Cameron. So he's next. Let's say he's in a car wreck. More likely it's going to be 16-year-old kid gets in a car wreck. And so 16-year-old kid, dad's going to get sued, mom and dad both. The creditor in this particular case cannot attach anything that happens to be in that trust for him and his descendants. Again, we set up these trusts both for your child throughout his or her life and then down to his or her kids. And typically what we're going to do within these trusts is say if your child is married but doesn't have any kids, it goes to the siblings, not to spouse. And they say, well, but I like her. It's like, well, I'm glad you like her, but let's just give you a hypothetical. What if he dies next year, she remarries the year after? Do you want it to go to that next guy and his kids, or you want to make sure it goes to your kids? Well, of course, our kids. And if he doesn't have any kids, then it goes to siblings. So that's my recommendations, the way we typically do that. So again, the question, can any creditor of Cameron attach any assets? No. Why? Again, it's not his property. It's owned in the trust. He happens to be the trustee. He happens to be the beneficiary, 100% control over everything, but not his stuff, can't reach it. Similar to Miranda, she's probably the sharpest of them all. So we're going to give her a business. She's sued on personal guarantees. Can anybody attach? No. Same answer. It's not hers. So So that works really good to protect your kids from the rest of the world. So a lot of people will say, oh, well, are their hands tied within this trust? They're the trustee. What can they do? What can they not do? So question is, sales and purchases of assets, are there any restrictions on any of them buying or selling assets? And the answer is no. Again, they're the trustee. So they can buy, sell, trade, do whatever they want to. They can also take money out whenever they want to without any creditor attaching the distributions. Now, third lecture, the next one in this series, we're going to talk about LLCs and how those work and some of the other things for asset protection, just comparing and contrasting. Let's just say your typical thing for an LLC is if you have rental property or you're doing a business or you just want to protect your assets, you can set up an LLC, limited liability company, have your assets held in there. Say, again, if you have a rental property, for example, what the LLC will do is it'll protect you as the owner from any liability that happens on the property, okay? So that's a good thing. The disadvantage of an LLC, contrasting with the advantage of a trust, is that in an LLC, the creditor who has a judgment against you can assert what's called a charging order, or basically it's a lien against your ownership of the LLC. So in the LLC, you no longer own the house or the bank account or whatever assets are in there. Your LLC does. You happen to own the LLC, but the LLC owns the asset. So the creditor with a judgment against you can lien your property. Your property in this case is the membership interest, the ownership interest of the LLC. What this says is if you ever make a distribution, the creditor gets it because they've attached your interest. So LLCs are really good to provide the barrier. You think of a castle, a moat, you got the alligators in the moat out there, you got the high walls, the drawbridge, so they can't pierce through the castle walls and get anything in there. The disadvantage of the LLC is you can't take anything out because the army has surrounded you, and if you go out, you get captured. So different situation with a trust. Different remedies, different laws. Again, it just helps to know what the laws are and to use them to your advantage. There's plenty of laws out there to protect you if you know how to use them. So in the trust, again, comparing here, you can take money out anytime. Robbie could, Cameron, Miranda, they can take the assets out and nobody can attach that distribution. So again, good thing. Advantage of an irrevocable trust over some of the other options. Okay, so again, why can't they attach? It's because they don't have the right. That's what the law says. All right. Distributions, are there any restrictions on them taking money out of the trust? And the answer is no. They're the trustee. Again, can any creditor attach? And the answer is no. Okay. And the term of art here it's called a spendthrift trust. That's kind of an archaic term, but what it means is nobody can attach assets in the trust or a distribution from it. Okay. Again, the solution here for control is each child can be the trustee of his or her trust. So, summary. Living trust benefits, you can set it up so the surviving spouse can get 100% protection throughout his or her life. You can have it set up in a way, A trust AB, where the spouse has complete control over everything. And in this case, again, in the situation of different sets of beneficiaries on both sides, you can make sure that the deceased spouse, that their beneficiaries don't get, his or her beneficiaries don't get cut out if during the life of the survivor. So those are nice things that you can do. Then going from spouse down to kids, again, B trust only protects half of the estate, and the B trust will last throughout the life of the spouse, survivor. So what happens here is within the trust, A portion, A, B, whatever it is, both of those last throughout the life of the spouse. Nothing happens down to the kids before mom and dad are both gone. Okay, you, again, not good to give your things away, both not only for tax reasons, like we talked about getting a stepped up basis, but if you're going to need it, don't give it away. All right, so the children, you can set up the trust for them. They can have their assets held in their trust free from any claims, divorces, accidents, bankruptcy, business failure, medical bills, etc. So, conclusion, living trusts are, again, better than doing nothing, better than a will. Have a living trust. It's the best way to transfer assets upon death. A lot of advantages over wills. And just to pitch the benefit of not doing things online, because they don't work 99.99% of the time. You might be in the 0.01, but I wouldn't risk it. So things you don't want to pay bottom dollar for: parachutes, obviously, scuba equipment, or estate planning documents or asset protection documents. I am biased this way, but I see a much disproportionately higher incident of bad things happening than probably you're familiar with, but I've seen it all. Basically, what you don't want to do with your estate planning or asset protection documents is have the wrong thing. You have huge stakes here. The main problem is once you find out there's a problem, it's too late. Okay, so had a graphic here that can't use on this. I can use it on live presentations, but not these. Shows an attorney going into the jail cell. There's an empty cot, and he goes, "Whoa, don't tell me you've been executed already." Doesn't happen in real life, but the concept is you want to get somebody who knows what they're doing. This is not simple A, B, and C. There's a lot of different issues that are involved. Your family is different than somebody else's family. You don't want to go with the lowest common denominator. So generally, you want to get somebody who knows what they're doing. He or she can help you with that. You don't want to cut corners here. Spend whatever you need to make sure it works, because that's what you want. And bottom line is it may end up costing more than you realize. So that concludes this presentation. I hope you learned something. I hope some of this has been beneficial, of help to you in some way. Again, if you're interested in learning about some of the asset protection things, that's in the 3rd and 4th in this series. So thank you for attending and listening, and I wish you all well.